Hey everyone, and welcome to today's Explainer. We are diving into a really fascinating and honestly kind of tangled regulatory maze today. We're unpacking California's 2026 canine law package, but we are looking at it specifically through the lens of the Marin County blueprint. So joining me to decode all these hypothetical ramifications is our resident canine legal expert host B, along with a very special guest. We have Paul Miller from Deep Dive Consulting and Bay Canine with us.
Thanks. Yeah, it's absolutely great to be here. You know, the intersection of AB 519, AB 506, and SB 312 has created what people are already calling an ocean of canine law. We're going to look specifically at how Marin County interprets and enforces these new statutes. And we mean everything from ground-level rescue ops all the way up to the Board of Supervisors. Paul, we are thrilled to have you here to walk us through your interpretive companion document.
Thanks so much for having me on. This explainer is really all about translating those massive, broad statewide mandates into hyper-local, Marin-specific scopes of inquiry. All right, so here is a quick look at the docket for today's briefing. We're going to move sequentially right through 6 distinct areas: animal control and intake, criminal fraud and prosecutions, civil actions in courts, jurisdictional and venue disputes, breeders, shows and services, and finally, local policy and governance. Let's jump right into Section 1, Animal Control and Intake, specifically the operational and regulatory impacts. My first big question here really revolves around field enforcement and custody chains under this new statutory regime. I'm especially curious about how Marin Humane is going to operate.
Right, so Paul, let's paint a picture here. Think about a pretty standard multi-stage rescue chain, right? You've got an out-of-state pull, an in-transit foster, a Marin-based foster, and finally, the adoption. Exactly when does that SB 312 10-day certificate of veterinarian inspection, that mandatory clean bill of health a dog needs to cross borders, when does that 10-day window actually begin?
And this right here perfectly illustrates the massive headache partner organizations are staring down. If a dog changes hands 4 times before final adoption, does Marin Humane consider that 10-day health window to have started at step 1 or at step 4? Because if that paperwork is missing or even just incomplete when an animal is surrendered in Marin, is that an automatic referral to the district attorney or is it handled internally? The ambiguity here is a huge prospective documentation challenge for literally any rescue operating in Marin. I mean, a court might adopt the entry point attachment reading, but a defendant could absolutely turn around and argue the obligation only attaches at final adoption.
And that ambiguity leads right into a potential trap hiding in AB 519's language. The statute explicitly uses the phrase arranging or facilitating for profit. So Paul, is Marin Humane's intake team even prepared for this broad definition to inadvertently capture folks who don't even self-identify as brokers? I'm joking about groomers or behaviorists like Virginia, who you actually mentioned in your notes.
That's a really critical microanalysis point to make. Does Marin Humane's existing partnership structure with those behaviorists create documentation exposure? Because if behavioral assessment records get linked to those health records, they could easily be jointly requested in a massive public records sweep. The statutory definition is just incredibly broad, and it could totally reach trainers and groomers if a fee is involved, effectively stripping away their intended exemptions.
Okay, let's pivot over to Section 2, Criminal Fraud and Prosecutions, looking at prosecutorial discretion and fraud patterns. We need to shift this discussion slightly to the district attorney's jurisdiction over these rescue laundering schemes.
So, Paul, if we have an operation that's clearly using the rescue exemption fraudulently, what exactly is the Marin DA's threshold for treating that as straight-up criminal fraud as opposed to just a civil matter under AB 506? How does Captain Hart's Special Crimes Unit even identify these patterns, and is the referral pathway for Marin Humane formalized, or is it more ad hoc? Well, given Marin's smaller caseload compared to some of the neighboring counties, they honestly might have more resources to deeply investigate these cases. If Captain Hart's unit spots a rescue laundering pattern, the real question is whether they strictly rely on formal complaints or if they lean on professional collaboration networks, like, say, Mary Quinn's 23-year history in the local training community, as actionable intelligence. Right now, navigating that specific threshold is a massive gray area for the defense.
And notice the stark conflict here. You've got the verifiable enrolled build text up against this completely documented false standard floating around the industry. The whole idea of a 50% refund or a 25% deposit cap.
Exactly. The report shows this standard is entirely false. So, if a broker relies on those fake deposit cap figures, does the DA's office treat that reliance as an aggravating factor in a fraud prosecution? Since the actual text of the law is independently verifiable, it's public record, a defendant trying to claim good faith reliance on industry misinformation might find that defense completely destroyed in a Marin courtroom. It's a really huge prosecutorial edge.
Which actually brings us perfectly to Section 3, Civil Actions in Courts. We'll be looking at civil enforcement and parallel proceedings, shifting our briefing over to Superior Court evidentiary standards, and that big parallel action question getting flagged statewide. Right, let's talk about tainted contracts. Paul, under AB 506, if a seller bundles a non-refundable deposit clause with a binding arbitration clause, how on earth does a Marin judge or county council evaluate that? Does voiding just the deposit clause taint the entire instrument as void as against public policy?
This is absolutely one of the most hotly contested issues for trial courts right now. If you have a void non-refundable deposit clause, does it just blow up the arbitration clause sitting right next to it? Will Marin's local court favor early motions to compel arbitration, or will they literally say the whole contract is poisoned? It's your classic one bad apple spoils the barrel scenario. This is entirely unsettled pending appellate guidance, but man, it's a massive risk for any breeder or broker relying on standard templates.
And when you look at this split between private civil actions driven by the buyer and public enforcement driven by Marin County Council, there's a really big question staring us in the face. Paul, does a private settlement actually protect a seller from the county? So the crucial takeaway here is that a settlement reached by a private buyer, even if it resolves their immediate dispute, does not necessarily stop county council from pursuing public enforcement against that exact same defendant for the exact same conduct. Marin could easily take the position that public enforcement standing survives a private settlement, totally regardless of whatever release language the buyer signed. So you could literally pay off the plaintiff to settle the issue on a Tuesday and still get sued by the county on Wednesday.
Wow, which opens the floor nicely to Section 4, Jurisdictional and Venue Disputes. Specifically, we need to get into the complexities of cross-jurisdictional enforcement, especially when we're talking about Marin and its neighbors like Sonoma or Alameda.
Yeah, this is the classic scale problem of parallel liability events. Paul, help us dissect this. If an out-of-state or even a Marin-based coaching platform distributes a flawed contract template statewide, but only a single transaction actually touches Marin County, is there sufficient nexus? Like, is there enough of a direct local connection to justify enforcement? Would a Marin court realistically allow discovery into that platform's full statewide client list based on just one local claim? That is quite literally the nightmare scenario for these professional blueprint platforms. A Marin court could absolutely treat the coaching platform itself as a third-party defendant under a negligent misrepresentation theory. And if they allow discovery into that full client list just to establish the scale of the flawed clauses, a single local complaint suddenly blows open liability events across the entire state of California. It's wild.
And we have to remember, Marin isn't just any county. It has a very specific demographic makeup that dramatically increases its civil litigation risk, doesn't it?
Absolutely it does. You have an affluent, high disposable income buyer base mixed with a very high concentration of legal and financial professionals. So you're dealing with legally sophisticated buyers. This makes local buyers prime targets for aggressive AB 56 private right of action lawsuits. Plaintiffs' attorneys are highly likely to forum shop toward Marin precisely because the transaction values are high and the buyers actually have the resources to litigate.
Okay, let's move along to Section 5, Breeders, Shows, and Services. We're going to drill down into the precise impacts on the Marin-specific sector scope, meaning its distinct professional and hobbyist canine population.
Paul, we have a massive, well-established show community here in Marin. Does a de minimis, a small-scale non-commercial carve-out exist in the statute for them? Like, if two credentialed handlers do a single private transfer of a show-line German Shepherd, are they entirely exposed to AB 506 disclosure rules? Well, as it stands currently, there is no explicit de minimis carve-out in the text that protects them. None. So even private, non-commercial transfers between hobbyist breeders within AKC-affiliated clubs could technically fall right into the statute's reach. This community really needs to coordinate with animal control immediately on how these laws will be practically applied to them on the ground, because the plain text leaves them highly exposed.
And this elegantly brings us to your specific background with Service Dog Shield. Consider the comparison here between a service dog placement, where the profit is essentially on the training, versus pet sale brokerage, where the profit is on the animal itself.
Right, so AB 519 does have an exemption for service animals. But how exactly does a Marin court handle a hybrid transaction? Let's say it starts as a standard pet sale, but then it's later represented as a service placement. Does that exemption immunize the entire transaction or only the portion tied directly to the training? Because if the fee structure makes it look like you're profiting off the dog itself rather than just your training services, you could very easily get pulled right into that broker definition.
Which brings us to the operational chill these laws might have on genuinely well-meaning programs. Think about a really beautiful initiative like Marin's Last Wishes program, which places dogs for seniors. Do they run afoul of AB 506 simply because they charge a nominal transfer fee just to cover their basic operational costs? Yes, and this is exactly the unintended consequence we worry about the most. If a placement involves literally any transfer fee, even a nominal one clearly not intended to generate profit, does that trigger the massive AB 506 disclosure exposure? It is a very real and honestly very unfortunate operational chill for community welfare programs.
Let's bring this briefing to its final phase. Section 6, Local Policy and Governance. We really need to examine the Board of Supervisors' horizon and those long-term policy adjustments required from local government. Paul, outline these impending administrative burdens for us. You refer to it in the notes as a documentation arms race. Yeah, the Board of Supervisors really has to prepare for an absolute influx of public records requests targeting rescue and breeder compliance histories. It's going to be a lot. When Marin Humane's contract comes up for renewal, they're likely going to need explicit funding for health compliance monitoring. Furthermore, the county might actually need to fund compliance as a service resources. Why? Because the small independent rescues and trainers who are most in need of this compliance infrastructure are exactly the ones least able to afford to build it themselves. Honestly, it's a bit like asking a mom-and-pop bakery to suddenly build a Silicon Valley tech compliance department.
Which leaves us staring down this final, incredibly provocative question. The state statutes are undeniably ambiguous. So, will Marin County step up and draft its own local ordinance to resolve this custody versus ownership issue before unequal enforcement just destroys local operations? It really is the billion-dollar question for local governance, because if they don't publish local guidance, the unequal enforcement outcomes within Marin alone could be totally devastating to the canine community. Paul, thank you so much for taking the time to break down this interpretive companion document with us today. And to our viewers, we really hope this explainer empowers you to further explore and prepare for the realities of California's new canine legal landscape. Thanks so much for joining us, and we'll catch you on the next one.